State of Florida versus George Zimmerman. Verdict: we, the jury, find George Zimmerman not guilty. So say we all.
Today, many Americans are trying to understand exactly why the jury reached that verdict. Lots of questions about how the prosecution handled the case. Helping me to help answer some questions are MSNBC legal analyst Lisa Bloom and former prosecutor Faith Jenkins. Thank you both for your time tonight.
Thank you.
Lisa, let me start with you. Where could the prosecution have done better?
Well, they could have argued a theory of the case, for starters, and closing argument. You know, when both sides are arguing reasonable doubt, I think an acquittal is a foregone conclusion, and they never did that. They went really to the defense theory of the case, especially the last half of the trial. So the defense has Zimmerman down, Trayvon Martin on top of him, assaulting him, and, you know, it's a fairly reasonable conclusion that George Zimmerman would have to defend himself in that situation, although not necessarily with deadly force. The prosecution could have argued that Zimmerman was on top. There were witnesses who said that. Or that the two men were upright and moving.
Their own witnesses there.
That's right. or that both men were upright and moving around and yelling at each other, as another prosecution witness demonstrated. The prosecution should have put together, most importantly, I mean, out of their probably dozen blunders in this case, the biggest one was their failure to put together in closing argument, by drawing reasonable inferences from the evidence, which is what prosecutors do, a theory of exactly what happened to counter the defense version.
Now, I want to answer what Lisa just said. If they would have put forth this was a fist fight. George Zimmerman had no serious injuries. He had a bloody nose. He had scratches to the back of his head. Trayvon Martin had no gun, no weapon. This was a fist fight. And the law is you cannot introduce a gun to a fist fight. Perhaps that would have been a better argument, to your point, Lisa. Just put it out there and say, this is what happened. They got into a fist fight, but George Zimmerman turned it into a gunfight, which he is not allowed to do.
Well, it's not even a gunfight. It was only one gun.
Right, but he introduced that to a fist fight, which is not the right thing to do.
Now, today in an interview, the prosecutor, Bernie D. Larienda, says that Mr. Zimmerman didn't testify. And let me play to you what he said.
As we all well know, he's got the right not to, and he made a decision.
He was afraid to take the stand.
The proof is in the pudding. Did he take the stand?
Now, he was afraid to take the stand. The proof is in the pudding. But wasn't it the prosecutors, by putting all of his statements in, they're saying to show the contradictions, but putting his statements in, didn't that create the climate where it became less and less necessary for him to testify?
That is correct. You know, many of us before the trial were really wondering whether Zimmerman would have to take the stand if the prosecutor forced his hand by not putting in exculpatory statements that made George Zimmerman look good. But the prosecutor put all of those in, and then it was a very clear decision that there was no way on earth the defense would have George Zimmerman testify. But the bottom line is, I never thought he was going to testify. Most defendants don't testify. There's any way they can get out of that cross-examination by a good prosecutor. To blame that one part of the trial for the loss in this case, I mean, as if that was unexpected, I mean, that's really startling. Zimmerman had a Fifth Amendment right not to testify. He exercised it.
Go ahead.
Well, here's what they said. The prosecutor said today they knew John Good was going to testify, and they believe, because you have to be able to put forth evidence that will get you a self-defense charge. The defense would want a self-defense charge. How would they get that if George Zimmerman doesn't take the witness stand? In most self-defense cases, the defendant has to testify. Here, because of John Good, the prosecutor said we knew that they would get the self-defense charge because of John Good, so we went ahead and put out his statements. The downside to that is, obviously, the jury wasn't convinced by his inconsistencies. He would have made a terrible witness on the witness stand. Look at what he said in the Hannity interview. You're going up against experienced prosecutors in cross-examining. So I think that the lies and the inconsistencies that he told would have been brought out much better on cross-examination in hindsight now.
If there's a civil suit, though, he would have to testify.
Yes, most likely.
Now, the state attorney, Angela Corey, she talked about the profiling part of the case. Look at this, Faith.
Trayvon Martin was profiled. There is no doubt that he was profiled to be a criminal. And if race was one of the aspects in George Zimmerman's mind, then we believe that we put out the proof necessary to show that Zimmerman did profile Trayvon Martin.
Now, this was the press conference after the verdict. We didn't hear that stressed a lot during the case, did we?
Well, they didn't use the word racial profile, but they used the word profiled. And they did emphasize that in the opening, in the closing, and through the introduction of those calls, which I know that they didn't mention in the closing arguments. But I think what they were arguing here is, look at all of the bad decisions and all the choices, the wrong assumptions that George Zimmerman made leading up to the moment where he meets Trayvon face to face. He wrongly assumes he's a criminal. He doesn't belong in the neighborhood. He calls him names, all of these things. And then they were hoping that the jury was going to say, look at all the wrong choices he made, and you cannot accept the fact and believe that he made the right choice when he pulled that trigger and decided to kill him.
Now, today we also see prosecutors offer their view of what happened that night. Look at this with me, Lisa.
Nobody just gets a gun out and shoots. Even trained police officers, when they're on the ground with a suspect on top of them, they can't get their guns out that quickly.
I think there was a struggle. At some point, Trayvon became aware of the gun and was backing up, and George Zimmerman shot him.
Now, this was a theory that we never heard during the case.
Yeah, it sure would have been good if the prosecutors, instead of talking to the media about these theories afterwards, would have offered them in the courtroom in the aggressive, direct, straightforward way that prosecutors do in every other murder trial in this country. I mean, that's what's really astounding to me. And for Angela Corey to say, well, we argued racial profiling. Was she watching the same trial that I was watching? Because actually what happened, and I just wrote a New York Times piece that's going to post any minute now on their website. What actually happened was prosecutors fought to get in those prior non-emergency calls that Zimmerman made, where in all cases where he called about a suspicious person in the neighborhood, in all cases, in 100% of the cases, it was an African-American person. They got that evidence in, and then they never used it. They never used it on cross-examination of a witness. They never used it in closing argument. They didn't play it back. So I think, and they said in closing arguments, this is not about race. So I think there was
100%.
a decision made midstream.
I don't think this would have changed
to
the
avoid
jury's
the
mind.
subject of race.
Lisa Bloom, Faith Jenkins, thank you both for your time tonight. Ahead, why this verdict and this case is shining light on controversial gun laws in America, plus taking action, protesters calling for justice and change. Stay with us.